Australia's next great environmental controversy. That's how former Federal Court Judge Murray Wilcox describes the proposal to build a major gas processing hub on WA's Dampier Peninsula on the Kimberley Coast. The Federal Environment Minister, Peter Garrett, is expected to decide on federal approvals or not for this project by mid-year. The gas will come from the massive Browse Basin, and Murray Wilcox has used his judicial skills to try and demolish the arguments for building the processing hub at James Price Point north of Broome. The site is the WA government's preferred location, and that choice has split the residents of Broome and also Kimberley's Aboriginal people. Justice Wilcox joins us now in the breakfast studio. Murray Wilcox, good morning.
Good morning, Fran.
You've described this project as highly damaging. What's your case against this hub?
There are really two strands to the case. One is an environmental case and the other is Indigenous cultural heritage damage. So far as the environmental case is concerned, the Kimberley is the last great wilderness area in Australia, one of the few left in the world. It's a magnificently beautiful area, as anybody who goes there knows. The area north of Broome on the Dampier Peninsula is relatively pristine. The proposal is to build an industrial hub 60 kilometres north of Broome, which will process gas brought ashore some 200 to 300 kilometres by pipeline from the Browse Basin for Woodside Energy. It's made clear by reports that were given to the West Australian Government a few years ago from resource companies that if that happens, they would be pushing to have bauxite mining at Mitchell Plateau, which is a sublimely beautiful area. It's really top quality area. There's bauxite deposits there, and bauxite involves strip mining, removing all of the vegetation. The bauxite would be brought down to the vicinity of the gas hub. There'd be an alumina refinery there, and the alumina would be then exported by ships from the jetties that are built to also export the liquefied natural gas which has been processed after being brought ashore from the Browse Basin. So in other words, this lovely area turns into an industrial hub, rather like the Karratha area of the Pilbara.
This is not an unusual tension, a tension between development, resource development, industrial development and the environment. This argument's been going for a long time. The argument for this hub was to try to stop it being, all this industrial activity being dispersed right throughout the Kimberley.
Well, there are 6 permit holders in the Browse Basin. One of them, INPEX, has already said it would pipe its gas to Darwin, where it would be processed in an existing plant. Shell have said that they will process it on a floating ship, well, they call it a ship, which will be close to their permit area. And they say that if they do that, it will be cheaper and it will produce 25% less greenhouse gases. Woodside have shown interest in James Price Point, and only yesterday with the West Australian Government said that it was their preferred site. The other 3 permit holders have made no commitment and are known to have been looking at Karratha. Woodside said yesterday that they would come in with Woodside. I don't know whether that's true. It hasn't been confirmed. But the point is that there are many alternatives. If you're simply just looking at gas processing, which is what Mr Barnett, the West Australian Premier, says, then you don't have to spoil this lovely area. If there's a hidden agenda, namely to open up the Mitchell Plateau, then Mr Barnett should say so. He's been asked to rule that out. And he says, I don't intend that. But when he's asked to ensure that it won't happen by protecting those areas, by putting them in National Park, or better still, in World Heritage nomination, he won't do that.
So you say opening it up beyond this processing hub?
Fran, as night follows day, that is what will happen.
Well, you taking up this cause has angered some of the Indigenous traditional owners of this area. In fact, Aboriginal people calling themselves, quote, the true traditional owners of James Price Point will be protesting outside your book launch today, claiming you've taken an anti-development, anti-Aboriginal stance on Aboriginal land without consulting them.
Well, I'm never anti-Aboriginal. I've always, in all my career, had a great deal of empathy with the Aboriginal cause. What happened here is the traditional owners of this area are a group called the Gullibaroo Jabba Jabba people. Their leader is a man called Joseph Rowe, who's been stalwartly against the gas hub from day one. There's no dispute that they are the traditional owners. They have a land claim that was put in a decade ago, long before gas was talked about. And even Mr Bergman, the chief executive of the Kimberley Land Council, in a letter only yesterday to me, said that they were the traditional owners. No dispute about that. There was a meeting held in April last year, which was advertised to people simply as report on progress with discussions with Woodside. Most of the Gullubaloo, Jabba Jabba people were not interested in doing a deal with Woodside, didn't bother to go. But people from, Aboriginal people from all over the Kimberley came in great numbers. On day 2, without any warning, a vote was called for. The Gullubaloo, Jabba Jabba people were upset at what happened and walked out. A vote was held and apparently some resolutions were passed. Mr Rowe subsequently asked Mr Bergman to give him a list of the people who attended the meeting and the minutes of the meeting. He's asked twice in writing. Mr Bergman hasn't provided that. Now, Mr Bergman wrote me a letter, which I got late on Monday night, attacking me for writing this without having consulted with the group that he called the Traditional Owners Negotiating Committee. I've never heard the claim that there was such a committee. I sent him an email yesterday asking him to identify what was the occasion of and the manner of giving the authority. I got back an email yesterday saying, in view of the imminence of the launch, he wouldn't provide the information. He had every opportunity of writing a letter back saying what was the decision. He's refused to reveal it. All I can say is that after looking at this for months, I have seen no evidence that there has been any decision by the relevant traditional owner group.
All right, and you've laid out your case in a book that you're distributing to every federal politician, presumably ahead of the government making a decision mid-year. Just finally, before I let you go, I must ask you about the...
Can I just add one thing on the point? This is a very vibrant cultural area. The gas plant will be in the middle of the Lurujari Trail, which is a 9-day walk, which is designed to teach the young people of the area and other people of the importance of their culture in that area. This will destroy it.
And just on another issue, Noel Pearson on Monday night told members of the American Bar Association that Australian native title law since the 1992 High Court decision has been, quote, an absolute travesty of misconception and intellectual shortcoming. He was especially critical of the High Court and the Federal Court. You were, of course, a judge on the Federal Court. You were. He said, we've had a High Court and the Federal Court that, in my view, has ill-served the Indigenous people of this nation. What's your reaction?
Well, I don't think I'd want to agree with Noel's actual language, but there certainly are major problems with the way the native title legislation is working. Put quite shortly, the Mabo case, which was the basis of it, concerned an offshore Torres Strait island where there was no doubt of the continuity of occupation for people over very many years and keeping the culture alive. Translated to the mainland of Australia, there are enormous difficulties, particularly where contact with the white people was early, was a long time ago. In practice, it's not possible to make out native title if contact with white people occurred before about the beginning of the 20th century, and that's because of the way the legislation has been interpreted. I'm not going to say whether that's right or wrong, but it's led to the unfortunate result that the more dispossessed you are, the less chance there is of being recognised as having any rights in that. I think it's unsatisfactory. I think the government should be looking at this, and I think the government is looking at whether there can be some at least form of recognition for people where there is disturbance. So I agree with Noel Pearson there's a problem. I don't agree with the language he's used to describe it.
Murray Wilcox, thank you for joining us again on Breakfast.
A pleasure. Yeah.
Murray Wilcox is a former federal court judge, and his book relating to the case, as he says it, the case against the plant in the Dampier Peninsula is called Kimberley at the Crossroads.